Right. Next up, we have Gregory Luce, speaking in favor. Welcome. Thanks for making the trip.
Thank you. Appreciate it. Thank you, Chairman Snyder and members of the committee. I appreciate the opportunity to speak in favor of Assembly Bill 502. My name is Gregory Luce. I'm an attorney and the founder of Adoptee Rights Law Center. I've represented and advised hundreds of adopted people across the country on issues involving identity documents, birth records, and U.S. citizenship for intercountry adoptees. I'm considered a national expert on the issue before you today and would welcome any questions. And it was hard for me not to jump in and try to answer those as you were having those questions because I typically know those answers. So feel free as I present to interrupt if you wish and to seek clarification because I hope I can provide that clarification. Before I get to the main portion of what I want to talk about, I want to talk about one important point that may influence how you view this issue. And one is under current Wisconsin law, there is no promise of anonymity to the birth record of an adopted person. It is, and Ledge Council could confirm this, it is up to the adoptive parents, and even if the adopted child, if the child is of age or of a certain age, to request that a new certificate be issued. If there is no request for such a certificate, none is issued, and the original birth certificate is retained as the only birth certificate. And two, there is no guarantee that the child that has been relinquished will ever be adopted. You had a bill right before this one in which you were discussing redaction of birth parent information. Well, we could have the very same circumstances surrounding a difficult situation such as what Representative Snodgrass raised about the birth parents having trouble and ultimately relinquishing or having a child removed from the home and placed in out-of-home placement. As that child grows up and that child is never adopted, there is no new amended birth certificate. That birth certificate remains, the original remains, and is available to that person at age 18. And so so the only difference, but what we're talking about here, is whether you are adopted or not. And a birth parent has no say, absolutely no say, whether a child is ultimately adopted. And that's a big distinction to get across. There are really 3 points that are critical to today's hearing to understand the issue. What is this about? Who do we trust? And what does it mean when we don't trust adopted people like me? This issue at its core is about this single piece of paper. This is my original birth certificate. I was born and adopted in the District of Columbia. I'm not claiming I'm a Badger. And I received this a little over a year ago, after a 20-year effort to get it, 5 years of which were spent in court. And I only got this recently, even though I knew for those 20 years every person who was on this piece of paper. I was there holding my birth mother's hand when she took her last breath, yet I still could not obtain the record showing that I was born to her nearly 57 years ago. And the District of Columbia has a similar law to Wisconsin's current law. There's an intermediary process. You have to pay for that, and you have to obtain the consent of the birth parent to release information. For the last 20 years, thousands of adopted people in Alabama have requested their original birth records, paid a small fee, and in a few weeks they received a copy of their own original birth record in the mail. More than 20,000 New York adoptees have requested their original birth records. 20,000 people in just the past 2 years. And they're receiving them as we speak. Again, after paying a fee and waiting for their certificate to come in the mail. Connecticut is the same. And in Oregon, more than 12,000 adopted people have received their original birth records over the last 20 years, without restriction or any reported incident. They fill out a form, pay a fee, and it arrives. Needless to say, Alaska and Kansas have always done this. They've never had restrictions. And with all these states, no known issues have been reported other than, with COVID, how long it is taking to get your birth record in the mail. That's generally the only complaint. These laws work. They are necessary laws because they are about the autonomy and freedom of adopted people like myself. in restoring that autonomy and freedom to possess your own birth information, the world has not fallen apart, adoption has not suffered, and lives have not been ruined because of this piece of truth. At most, there has been relief that the myths, the secrets, and the shame that has been embedded into adoptions long ago is finally being addressed truthfully and fully in a way that humans and citizens are trusted to handle themselves. That is, the people involved in this issue are able to put it to rest, honestly, and without creating and protecting state-sponsored secrets. This issue is also about trust. It is about treating people like me, or Diana, or Erica, or others who are going to testify or have testified today, not as perpetual children, who must come here year after year to beg for their own documents, many of whom already know what is on that document. What we are talking about, what is always the elephant in the room in these hearings, and I've seen and participated in many of them, is the notion that one, birth parents do not want to be found, and two, birth parents are publicly outed once they are found. That's a false and damaging assumption, and does not reflect reality. And it is most obviously laid bare by the fact that this state, its government, its agencies, its child-placing services, is obligated by law to go out and do what many people say we should never do, track down birth parents. Current law in Wisconsin requires that whenever an adopted person requests this single piece of paper, the state goes out and tracks the listed parents down. It's what's known as Wisconsin's Adoption Search Records Program, which we've talked about. And that search, that effort of the state to track birth parents down, is extensive. It is, as the Vital Records Registrar in my resident state of Minnesota once said of a very similar process, highly disruptive. Under current law, Wisconsin law, when an adult adopted person in Wisconsin requests their own birth record, a record that states factually where they were born, to whom they were born, and verifies that birth as theirs, the state's apparatus moves into place. Current Wisconsin regulations state what an adoption search must look like. The regulations in Chapter 53 of the Administrative Code state, quote, adoption search activities shall include, but are not limited to, checking or contacting, 1, the current address on file at the department or agency, 2, known close birth relatives who may know the location of the birth parent, 3, directories, 4, motor vehicle records, 5, marriage and death certificates, 6, the family's physician, 7, occupational licensing records, 8, church records, 9, public agency records, 10, divorce records, and 11, probate records. In addition, and I quote, when it appears that a sought-after birth parent has been identified and located, the searcher shall first attempt to make contact with the birth parent by telephone. If the presumed birth parent has no telephone or cannot be contacted by telephone, the searcher shall attempt contact either through a home visit or a letter. A home visit to the birth parent's house. That's the knock on the door we've talked about. And it's by a state agency or state worker or an agency worker. And yet when we as adoptees pursue one thing, this single piece of paper I'm holding here that contains the facts of our own birth and no one else's birth, we are told we cannot be trusted with this information. We are told that we do not deserve this information. We are told exaggerated horror stories where a person like me, like your brother or sister or coworker, has popped up at the door of a scared birth parent, even though a state worker is obligated by law to do that very same thing. Given that background, let's be clear about what this issue is about. It is about civil rights and the trust required of those who possess those rights. It is about whether you trust the adopted people in this room and across this state and the world, the 6 million of us here in the United States, who are your brothers, nieces, uncles, bosses, employees, friends, colleagues, even your parents and grandparents. The primary question before you is not what about birth parent privacy, but is, do you trust us with our own factual birth information? Because rather than trust adopted people whose lived experience establish them as the experts in navigating these issues, you trust the state of Wisconsin and the extensive apparatus it has set up, and for which we pay to do what a single piece of paper does in its place. We ask for the same trust you have in your fellow Wisconsinites in regulating our own personal affairs. We ask that you restore a right every adopted person in the United States once had, the the right to request and obtain your own original birth record. This single piece of paper, by simple request. I ask that you vote favorably in favor of Assembly Bill 502. Thank you.
All right.
And I'm open to any questions.
You bet. Thank you very much for your testimony and making the trip here. Could you address some of the concerns the attorney from the state bar had about, these issues and privacy of the birth parents and if it's legal or not?
Sure, it's certainly legal. I mean, it's been, I think David Bohl talked about any constitutional issues that have come up in the past, and those have been overruled as to what the birth parents said there was a claim of absolute anonymity, and it's not true. What I say to the state bar is that they need to be careful of what we're talking about. Again, we're talking about this piece of paper. In adoption, there are all sorts of different records that exist. There's the birth record as its simplest form. There are the court records, which have greater information. There are the adoption agency records that have the vast amount of information. There may be maternity home records. There may be hospital records. We're talking about the birth record. We're not talking about delving into what happened at the agency level that the state bar representative talked about, in which you're having this conversation with a birth parent and the excruciating decision as to whether to relinquish a child or not. Those are confidential. We're not prying into that information. We're not asking for that information. We're not asking about the circumstances of that relinquishment, and we're not getting those records. So we need to be very careful what records we're talking about when people say, well, this is going to open up all records and we're going to expose the birth parents to damaging information. That's not the case. And what I want to also be clear about, this is not about search. This is about this simple piece of paper. What we do with it is up to us. And many adoptees don't search. Many adoptees find out that their parents are deceased. But it's trusting us with this piece of information.
Any questions from committee members? All right. Thank you so much for your testimony and making the trip here.